Now, so today is an introduction class where we'll talk about the topics on the screen to make you an initial and bring you up to an initial understanding about the tort. Hmm? So, yes. Now, tort is separate from criminal and the civil subjects of law, right? So there must be some reason it was created. Because why somebody would create a third discipline when we have a clear distinction of criminal and civil, purely civil and criminal? Because tort is not purely civil, not purely criminal. It is somewhere in between. Now, tort law was developed as a separate, distinct entity from criminal and from civil laws due to its unique purpose and scope. So, it's an outcome based differentiation which differentiates tort from both of them. Now, while criminal laws, we all know, they deal with offenses against the state, and the civil laws cover dispute between individuals. The tort law specially addresses wrongful acts that cause harm to individuals, their property, or reputation without necessarily being a criminal. So it does covers the dispute between individuals. The wrongful act, what happens? Hmm? Not dispute. So basically, the wrongful acts which happen between the individuals, their property or reputation also, but not criminal in nature. Now, I would suggest all of you to keep pen and paper always handy because the way we go is we continue the session until end to ensure the recording is complete with the lecture. At the end, we'll have question answer session. So you keep writing your questions. Now, reasons for separation of tort law. On what grounds? So there are various schools of thoughts. Yes, sir. Now, one is why it is different. We have focus on compensation rather than punishment. So if you're talking about tort, criminal, sorry, the focus is more on punishment. Now, criminal law punishes wrongdoers on behalf of the society. Every law is made on behalf of society. While the tort law, it is focusing on compensating the victim for whatever harm he or she has suffered. Now, civil law, how differentiate is, primarily deals with contractual disputes. Primarily, it is contractual disputes, rights on property, rights on personal relationship, while tort covers only wrongful acts that do not arise from contractual obligation. There is no contract, but something wrong which has happened. Second broader classification is fault and liability principle, which goes with tort. So, tort introduces a unique liability concept such as negligence, strict liability, and vicarious liability, which are not central to criminal or general civil law. This is not central to the criminal and general civil law. Primarily, it is unique liability concepts. Now, in criminal cases, intent, which is the mens rea, is very essential, while tort often relies on negligence, which is lack of reasonable care rather than intent. So the loss of intent or partial intent. So the reasonable care is missing. The third point, which is the point of differentiation for tort from other two schools of law, is private versus public interest. So criminal law is enforced by the state to maintain public order. So any criminal matter which happens, that happens against the accused persons, and for the state, because state guarantees you freedom, liberty, uh, safety, and all those things which is required for any individual to survive and fulfill his livelihood. So, criminal laws are enforced by the state to maintain public order, whereas tort law is initiated by individuals seeking personal remedies. So, here the first party is always the individuals who are seeking personal remedies. Civil law covers broader legal representation relationships like contract, property dispute, but tort laws focuses especially on wrongful act caused harm to that person. I'm going on differentiation on every ground. Fourth ground is preventive and corrective justice. Criminal law or civil law might have some flavor, but purely tort is preventive and corrective injustice. So tort law not only compensate victim, but also act as a deterrent by holding individuals and entities accountable for harm caused by their action or omission. So if somebody it acts as a deterrent by holding individuals and entities as well accountable for harm caused by their action or omission. Now, it plays a role in influencing social behavior by encouraging safer practices. What would be the examples of it? For example, medical negligence, consumer protection, workplace safety, all of these come under tort. Fifth ground is types of harm which is addressed, which differentiates torts from legal, criminal and civil. So tort covers a wide range of wrongs, including personal injury, defamation, nuisance, trespass, professional negligence by a doctor or anybody, which do not always fit neatly into contract or criminal law. Because there is no, probably there might be negligence or not enough care taken instead of intent of doing that, instead of having a contract there. So tort law serves as a bridge between criminal and civil law. It uses the small principles from both the side, ensuring that individuals have a mechanism to seek justice and compensation when they suffer from due to another's wrongful conduct, which is not criminal. Its distinct legal principle also safeguard you when there is no contract actually between the parties, and remedies justify its existence as an independent legal discipline. So it is actually lying between both of them. It is not separately lying in a third direction. Tort is somewhere lying between the criminal and the civil jurisdiction of law, and it fills up that gap. So it primarily focuses on the civil laws. Compensation is something which it is oriented into. It mostly looks into the fault and liability principle because it cannot look into the crime and punishment. Tort is not for that. It looks for private versus public interest, and it's preventive and corrective. And it is also depending upon types of harms which are addressed. So these are the things which define why tort is there and why tort is in between the criminal and the civil, not a separate third dimension of subject. It is actually bringing in, uh, you know, uh, principles from both the areas. But end of the day, everything sums to one direction, whether it's criminal, civil, or tort, to ensure the person gets the required justice wherever there is a fault which is happening against him and where the other person has not actually made a criminal or a civil wrong. Because if that is not the case, where would the people go if such an action happens and there is no such provision available for them to get a remedy? Okay. So we can very clearly say tort is a critical area because it is more towards the civil side than the criminal side, because it's something which is where your rights are taken away, but it's not criminal in nature. So we can safely say it is more aligned towards the civil side of the litigations. So tort law is a critical area of civil law. As it is more closer to civil law, we can say it's part of a civil law, more towards civil law, focused on providing remedies to individuals whose rights have been violated to the wrongful act of others, due to the wrongful act of others. Now, it derives from a Latin word. The tort word comes from a Latin word called tortum, which means twisted, wrong, not correct, which is not, it was supposed to be. If we say in one line, it's tort means something which was not supposed to happen, which has happened, which aptly captures the essence of the actions it seeks to address. Now, tort law plays a fundamental role in maintaining social order. Why it is required a social order? Because if it is not addressed at the level of tort, it might either go to the civil litigation fully or it might end up into a criminal litigation. So it is required to maintain a social order by holding individuals and entities accountable for their actions, deterring harmful behavior, and ensuring that victims can obtain compensation for their injuries or damages, which is avoiding any further criminal activity, criminal act, or any civil litigation, full-fledged civil litigation. So we can categorize the function of the tort into three categories. The three main areas could be, one is why it is available, one is for deterrence, one is for redressal, and one for finally for justice. So by imposing liability for any wrongful action, we can create deterrence. So we impose liability that if you do this, this is the liability you get. So deterrence is created. So tort law seeks to deter individuals and organizations from engaging in harmful behavior that could injure others. Second is redressal. So basically, if I am able to deter somebody, if I am able to define something under tort, what I need to do further is to mechanism to individual to seek compensation for harm, which is nothing but redressal. Help to restore their original position as much as possible, what they were supposed to be into. Third point, the third main area which is covered by tort apart from deterrence and redressal is justice. So tort law serve as a broader goal of achieving social justice and creating order by recognizing the rights and dignity of individuals who have suffered due to someone else's actions. So as we delve into the details of tort law, we'll cover some of the definitions, characteristics, and the relation it holds with other areas of law, which is enriching in nature with some examples which we'll present with everything what we'll talk. It's very difficult to find sometimes. Students, it's very difficult sometime, even for a fresh lawyer or sometimes a seasoned lawyer also, to recognize tort or sometimes differentiate between tort, criminal, and civil. So what we are going to do is we'll speak about the subject with as much possible as examples, because examples will stay back in your mind to direct your thoughts in that direction. So let's first talk about the first topic. Tort is a civil wrong. This is more towards civil. So it's a fundamentally a civil wrong, because criminal, if there was even a single element of crime into it, it would find its place in criminal side, because there cannot be a smaller punishment for a crime. There cannot be a representation by individual if it is crime, and then it is something that becomes much more harsher. So individual to seek repartitions rather than facing criminal prosecutions. So it is more towards civil. So the civil nature, and again in criminal, we cannot come to a conclusion until and unless we have reasons beyond the doubt to justify somebody has made a crime. It needs a very long procedure of trial with a very strong evidence stage and lot of cross and various other examinations. So this civil nature is crucial. That is why it lies more in civil side of it. It distinguishes tort from crime for all those reasons which I just mentioned, which are prosecuted by the state and requires proof beyond a reasonable doubt. Let's take an example of scenario one when we talk about tort as a civil. Consider a scenario now where a dog owner, say A fails to secure the dog properly. Now the dog obviously will bite somebody or other and it bites a neighbor B. The neighbor can bring a tort claim against the dog owner for damages related to medical expenses and emotional distress. Was there a remedy in contract regarding that? Was there a contract between the person and the neighbor that if I have a dog, if it bites you, I'll pay you 10% of your salary or my salary. If a dog bites you, then I pay you 50 rupees on fixed amount every day you suffer. No, it was not there. Was there a
No,
criminal section which was there to help? Would there be a state representation against the dog which has bitten? Actually, no. So it
no,
was
sir.
lying between criminal and civil purely. So it lies between more towards civil. Now, this action arises from a civil wrong where the neighbor seeks compensation for harm caused by the owner's negligence and it will be tried as a tort. Bharat, are you unmuted? Please mute yourself. Then let's talk a second scenario also, which will help you further. A person is injured when an unstable shelf collapses in a supermarket. So the person goes to the supermarket, you go to DMart, and somebody has kept 500 kgs of garam masala on the top. The shelf breaks and the supermarket shelf comes and collapses on you. The store may have failed to inspect and maintain its shelves adequately. That is a different thing. That's a different aspect of it. But the injured individual can sue the supermarket for the damages. You have broken one rib bone here, or you have got scratches, deep wound, whatever it is. So you can ask for that particular medical negligence, the cost, the negligence of to maintain their property. So the medical cost, and if you have lost some wages, some salaries because you're absent, you can claim that. That is where it necessitates the necessity of getting a compensation when it is not categorized clearly into a criminal or a civil side. So the very first part what we talked about is tort is a civil wrong, definitely not a criminal wrong. And what it seeks is compensation and different redressal options and mechanism to ensure you're compensated back for what you deserve to come back to the original state. In these two scenarios, when the dog bites, when the shelf falls on the top of the head, in both the scenarios, both the people got restored through to their previous. I mean, this is not a press of button, they become fine, but it gives them enough means to come back to the original situation. That is what the tort is doing. If tort is other than a mere breach of contract or it is breach of trust. So tort law focuses on a wrongful action regardless of contractual obligation. So any wrongful action which is there, which has happened, for which there is a contractual obligation, yes or no, does not matter. So even in absence of a contractual matter, tort is still applicable because it is not purely civil, as I said initially. So this distinction is significant. That says the tort can occur between parties, one, two, three, whatever the parties who have no formal agreement or no duty arising out of the contract. Because when you have a contract, you have certain duties you have to follow. You have to go through some rituals of contracting. You have to pen down certain contract amounts. You have to have some wordings around that. So all those things make it a clear-cut contract. So when we see point two, tort is other than a mere breach of contract or breach of trust. No, it is not. The reason being, it is something which is still available for your recourse rescue and for your support where there is no actual contract exiting. It doesn't mean there is a matters if there is a contract there or not. So that is where the tort is not something which is mere breach of contract or breach of trust. It exists to universally to restore your rights and restore your position to the normal state in case you have suffered. Let's take an example to understand this. In fact, we'll take two examples to understand this. Point two, tort is other than a mere breach of contract or breach of trust. Now, if a person throws a rock through a neighbor's window, hmm, the neighbor is standing there in his balcony and he throws a rock through a neighbor's window. That person commits a tort of vandalism, right? He is not doing it, with any contract, irrespective of any contractual relationship with the neighbor. You have no contractual relationship with neighbors, right? You stay in a house, the other person who comes and buys the next house is none of your responsibility or control. So you have no any relationship actually might be between you and the neighbor. You might not know each other also. The affected neighbor can seek damages for the repair of the window under vandalism. Yes, you can file a criminal case against the person for seeking, the punishment he deserves or reprimand he deserves from the court in a criminal court. That is fine. But the compensation, how would you claim under the pure civil laws? You cannot, because there is no contract between you and the other party. That is where the tort is a mean where you can claim still you can claim a compensation where through tort, which is going to help you in spite of no contract actual between you and the neighbor, and there is no question of any trust breach or any contractual breakage. Let's do example two. A restaurant serves a food that is contaminated. It has some issues where it is infested by some bacteria, worms, etc. This leads to a severe food poisoning among its patrons. So 5, 6 people who have gone there that night and whatever they have ate, so they have got all infected and they have got belly belly, as they say. Huh? So the customers can then file a tort claim for negligence against the restaurant, even though they did not have a specific contract regarding the quality of the food served. What FDA does with them on the complaint, what ban happens to them through FDA is a separate thing. But the claim of the compensation here, between what is the most important thing for you here is not the person goes to jail or the shop is closed. The very first thing is you have spent money, you have suffered, and you need that compensation. There is no compensation, no contract you sign with the restaurant when you enter that if I eat your food, if I get sick, you will pay me. That is by default understood. It's implied. And this example scenario 2 says, because of this tort existence, you can go back and still claim to the restaurant. So tort is other than a mere breach of contract or breach of trust. It is not only a mere breach of contract or breach of trust. It is more than that. It is other than that. So it is still available for the remedy for the people in spite of having no possibility of a breach of contract or breach of trust also, because it doesn't exist there. Now the question comes, tort is redressable by action for unliquidated damages. Is it yes or no? So can we have a redressal by action of unliquidated damages? Now, tort law typically deals with unliquidated damages only. So damages that are not fixed and must be quantified based on evidence presented during litigation. This is distinct from contractual claims where damages are often predetermined. So when you have a contract breach, when it is failed, you already know you have contracted for how much amount or how much volume of goods or quantity or how much level of service, what is the monetary losses you could have. It could be easily calculated, plus the interest, how it has to be given by the uh, prevalent interest rate of a nationalized bank and all that, right? But this is unliquidated damages. You exactly do not know when the damage happens, or it was not planned before the damage happens, rightly said. that what is the quantification of the damage which will be which needs to be redressed. It is calculated during the litigation. So in that case, tort is redressable by action for unliquidated damages. Yes. So let's take two examples to understand. One is, say for in a traffic, you're going somewhere and there is a traffic accident happens to somebody. So the injured party suffers from a broken leg, loses 2 inches of his leg, incurs medical expenses. They can file a tort claim seeking compensation for medical bills, pain and suffering, and potential loss of wages also. The court will evaluate various factors to determine the amount of damages based on the individual circumstances. I mean, of course, you will go for the Motor Vehicle Act and you will go for a compensation through the insurance company also. But if we keep that aside, that was the thing which was the thing of the past. People used to do that. Let's take a second example. Um, for example, a very famous person faces a defamation through a false statement published in newspaper. So somebody has published something about him or her which is completely false and baseless. In that case, was there a contract? Was there a contract against with the person who has published that I'll not publish anything wrong? If it is found wrong, I'll so and so amount I'll pay to you. No, it is not. It's just random. It has happened. It has happened. So they suffer reputational damages, emotional distress. People who are near and dear might have come back and there might have strain in the relationship because of that. There is a loss of business opportunity because companies might have shrinked to give him any opportunity going ahead, seeing his reputation loss. So all these losses can happen, and the damages which could be awarded through a compensation are again unliquidated, because it has to be, first of all, produced by the person in terms of numbers by the time it has happened, what numbers has the quantum of the loss which has happened to him or her, and what are the other damages which could be quantified in terms of money to punish the other party to recover his damages. I mean, if an emotional damage has happened, there cannot be a price for that. But then there could be always a price which could make me little happy that okay, if I've lost this, I've something there in my hand at least in in place of that. So that is again an unliquidated damage. So if we talk about the nature of the tort in terms of redressable by action for unliquidated damages, yes, it has to be done redressed by action of an unliquidated damage, because in tort, which is, as we understand, it is lying between criminal and civil, it more shifts towards civil, but it is not completely civil, but it is a civil wrong because it's more towards civil. Tort is not mere a breach of contract or breach of trust. It is not criminal in nature. Otherwise, it could never be tried in either way, or tort or civil. It is redressable by action for unliquidated damages. So always keep in mind, tort has got the redressal can happen only through unliquidated damages. Now, fourth point says the nature of tort can be understood by distinguishing. What does it mean? So understanding the tort requires distinguishing them from other wrongful act, particularly in relation to criminal law, contract law, fiduciary duties, and quasi contract. So it has to be distinguished in that manner. So once you are facing a situation where you believe something is tort, you have to go back and you have to see that is it really in the nature of tort or it is not. Is it really in the nature of contract or not? Right? The fifth point says tort and crime are distinguished. We are seeing from the very start of this lecture today that tort and crime sometimes overlapping. As we say, the vandalism has happened, the glass was broken, but they serve different purposes. I told you, when somebody has done a vandalism by breaking the window glass, my purpose is either to punish that person, let him go to the jail, or my purpose is to also get compensation. So if I need to get compensation, criminal law is not going to help. And there is no civil remedy available to me because I don't have a contractual responsibility. What is there between us is the liability, and that liability to ensure my status is coming back to the original status. In this case, the window, which has to be done by compensation, plus whatever it took me to, manage that cleaning, bringing the articles there, bringing an extra wages for staff, or spending my time or in loss of my wages or my income. All of those is far more important for you, and that is where you determine and understand the different purposes of criminal and the tort law. So if you want to take the tort route, that is the only route available for you to get compensation. If you file a criminal matter, you pursue it in a criminal way, it will only help you to see and make yourself happy if the person is probably not arrested in this case, but then has to visit the court multiple times. So torts are designed to provide relief to affected parties. So it is more towards relief, while crime is something which is to protect yourself in public interest or prosecute somebody by the state. So in this case, tort and crime are very clearly distinguished. So coming to point 4 back, the nature of the tort distinguished from other legal concepts. When we try to isolate an activity, sometimes it might lie in between or overlapping in both the areas. For example, in this case, it is overlapping with crime because there vandalism has happened, and tort where I seek a recovery. So then you have to take the route which suits you from tort perspective if you want to go in that direction. And that is where tort has clearly this clear distinction from the sake of purpose. What do you want to achieve? Take an example. A person is injured during an assault. So an assault happens, some other individuals come and assaults that person. Now the assailant is charged with a crime, facing criminal penalty like imprisonment, or maybe an immediate arrest where he has to seek a bail. Simultaneously, the injured individual can also pursue a matter for tort for compensation covering medical expense and suffering due to the assault. So, for example, one of my client, he was a veterinary doctor, very famous case in Hadapsar. Hmm. He was assaulted by a patient's family, where the patient brought a cat for the treatment, and the cat was in a very bad shape. It came and it died on the table of the doctor. The assailants in this case, the family who brought the cat, they did a huge damage to the doctor's clinic, and they, assaulted him so much that they broke one of his ligament, couple of bones in the leg. So criminal act was part of it. Doctor was assaulted. Police arrested them. They have to seek bail. But was it going to compensate my client? No. To compensate the client, what was the route? It was tort, where it was filed, and the compensation was sought. It was an unliquidated damage because there was no plan, there was no contract also to quantify what was already the damage. Whatever the equipments were damaged, whatever evidences could be produced, and the number of days of wages which the doctor lost because being on the bed. So this is one example. Another one could be tax evasion. It's a crime against the state punishable by fines or imprisonment if the illegality is proved against the offender, such as lender being deprived of anticipated interest from loan repayment, etc. They could potentially go for a tax matter, financial matter in the crime side, and they can get the person punished for fraud, for whatever it is. But what is more required for the banks or for the tax agencies is to levy the charges to get the money back. And it is also, in a way, an action where the recovery is made. So basically, point 4 and 5 also clearly tells us the nature of the tort can be understood by distinguishing it clearly from civil and criminal, while the point 5 clearly says if you want to distinguish, You might have overlap. Please understand the purpose of both tort and crime, and based on that, you can easily understand what route you have to take. So this is how the crime distinguishes. So we have distinguished crime and tort by purpose. Now, similar lines, let's talk about tort and breach of contract distinction. So why tort and breach of contract could be distinct, as we have talked about in criminal law, distinction between tort and criminal law. Similarly, there could be something between contract and tort because it lies more towards civil, as I said, but it is not purely civil. It lies more towards civil, so we call it more towards civil, so it is called civil, but it is not actually 100% civil. So while breaches of contract involve the violation of an agreement, the very first criteria, if a civil matter arises, is a contract. In case of contract, is the breach of contract. It involves violation of the agreement term. Tort can happen independent of any existing contract obligation, which has significant implication for liability and remedies. Right. So the very big distinction between crime and tort, if they overlap, is the purpose what you want to achieve or what the purpose we want to achieve, while the contract, which is civil, and tort distinguished by even without existing of a pre-existing contract, you can still sue, and that's where the tort stands. Take an example again. So I'm talking about example for point number 6. So imagine a scenario where a party hires a moving company. So there are companies we do this moving job, movers and packers. This company is supposed to transport their household goods, furniture, etc. Now, if the company fails to deliver the item as promised and simply keeps them with them, the client can sue the breach of contract, that they have a contract with me where they were supposed to deliver my goods to point A to point B, but they have taken it from point A and somewhere at point C they have kept it with themselves. They have not delivered. This is breach of contract. However, if the movers and packer were to the driver of that company does a reckless driving and causes an accident, or even not accident, he does a lot of bumps on the speed breaker, and because of that, a lot of my furniture, electronic goods have been damaged or dented. If I have bought a insurance, good for both the parties. Otherwise, the only route I have here is this tort. Through tort, I can recover my damages. Were they quantified earlier as the nature of contract? No. They were all unliquidated damages, which has happened by the action, random action of the driver, whether he has either collided completely with a tree and damaged everything, or he has done a reckless driving, damaging a lot of things because of he has jumped a lot of speed breakers and he has inadvertently has broken a lot of things. So here comes the tort for your remedy. Let's take another example. Consider a case where an individual has a contract with a photographer. There is a wedding and you have hired a wedding photographer. Now, if the photographer fails to show up or he clicks the picture and he does not develops it for you or he does not prints it for you, it's a breach of contract. So the person, whoever is hired, can sue him for that particular breach of contract. But if the same photographer during another session damages someone's property while setting up light, now he has come to your place and he has set up light, etc., and he has damaged things. Or while photography, he has pushed a very expensive vessel or something very expensive, he has broken that. He has done some damages collaterally while his action during the cinema shoot or the video shoot in the marriage. Was it somewhere considered in the contract by the smallest of the imagination, by the least of the imagination? It is not. It cannot be. You cannot have a contract with a implied or expressed contract. Either way, you cannot have with a photographer saying, "Boss, You have a breach of contract if you don't do it properly, if you don't bring it on time, if you deliver it or fail to deliver it, if you come, don't come. All these things are covered in breach. But by the, you know, farthest of imagination, nobody can think and come back and say you will come and broke one of my vessel, one important imported glass vessel you have broken, or such kind of collateral damage you have done. It cannot be part of any contract, right? So that is where such kind of remedies are actually not fully civil in nature. They are neither criminal in nature in this case, but they could be you using tort, it could be uh, recovered. The redressal is possible. So this is what is tort of distinction of tort with crime and distinction of tort with contract. And both of the cases, if you see, the in terms of crime, it is the purpose which distinguishes. In terms of contract, again, it is something the subject which is out of the contract and which is irrespective of contract which has happened. Now, privity of contract and tortious liability. So, privity of contract means relationship between parties in a contract wherein only they are bound by its terms and conditions. In contrast to this, the tort law allows for liability to parties who may not have any contractual association, which is purely called as tortious liability. So, what is the name of this liability? Is it a contractual liability? No, it's a tortious liability which exists. We call it as a tortious liability. It is not under the privity of any contract. Privity of contract means a relationship which is covered by the terms and conditions. So, the terms and condition based relationship, which is privity of that contract, the sphere of that contract, it is not there. It is not because of the purpose of the contract. It is a tortious liability. So, if a guest comes to a rented venue and he slips because your floor is slippery, they can bring a tort claim against the venue owner. So I've taken a house on rent to bring all my guests, stay there for the wedding. They come, there are multiple 10 rooms are given. This is maintained by the person who has given the house on rent. He charges me for the service of the house cleaning and everything. In that house, one of my guests slips in the bedroom and he has broken one of his bones. So the tort claim can happen against the venue owner, even if they were not a party to the contract between the venue owner and the event host. So the venue owner could be penalized. The venue has a duty of care to ensure that all guests are safe. So I am the host. It is not my responsibility in this case to ensure on the ground my guests are safe. But you, somebody as the venue owner who has promised me to give a high quality venue which is safe, comfortable, and good in space with all the facilities for my guest, you have broken a condition which has put me in a situation where the guest has broken his leg. It cannot be covered in all the dimensions. So we can also say in terms of tort, if we compare little bit with the contract, by far of imaginations, whatever could happen, irrespective of being covered in the contract, and which causes a harm to one party because of action or omission of the other party is a tort. And that is why the nature, if you have noticed until now with the examples, the more of the nature of of this tort or the tortious liability is towards civil side. You want to, in civil, what you do, you get damages, you get compensation, you get a parcel of land. So what is happening mostly is you get a compensation. So more because of its nature of recovering a compensation, that is why it shifts more towards the civil side of it. Let's take another example. I'm still on the topic privity of contract and tortious liability. Now, In the previous one, we see there was no privity of contract in this case. The person slipped, the venue owner was liable under tort, and he was supposed to pay the compensation for medical and whatever the losses have happened. Let's take second example. A manufacturer produces defective car parts and the part fails, causing an accident. So the brake component was not fine when he tried to put a brake at the right time. The car smashes the wall and goes inside. The injured party can sue the manufacturer for negligence or product liability, even though they purchased the car from a dealer and have no direct contractual relation with them. So if I have a Maruti car, if I have gone and if I have a Honda car, if I have a Audi, whatever it is, I just cannot, I'm not required to go back for this damage because it has come and it has happened because of some kind of faulty equipment within the vehicle, and I have broken somebody's car or somebody's bones. I paid for that as a compensation myself, and I have got a reputation, bad reputation of myself as well as somebody who has drives very carelessly, recklessly in my community. I need not go back and sue the person who has sold me the car to me or the company which has sold the car to me. I have a directly tortious relationship with the manufacturer of the car, and that in spite of having no contract. I have a contract with the person with whom I purchased the car, right? I have that he deliver me a good car and blah blah blah. But it is not under his control also. He would not know if a brake is fine or not, if a certain equipment is fine or not within the machineries of the car, which is hidden to the eyes. That is where the tortoise relationship help you to sue that person in spite of non-presence of any privity of contract. The tortoise liability comes to your rescue. Let's talk to about the point number 8. So tort and breach of trust distinguished. Now we have talked about breach of contract. If you see point number 2, we talked about tort is other than mere breach of contract or breach of trust. So breach of contract we just spoke about. Breach of the criminal crime distinguishing we have done. Now let's talk about torts and breach of trust, how it is distinguished. Now breach of trust involves a fiduciary relationship where one party is in a position of trust to act in the best interest of the other party. So tort can occur independently and do not require a fiduciary duty. So what is a fiduciary relationship? Where one party is in position of trust and to act in the best interest of other party. So that is the relationship already defines. This is how it has to be. Now, for example, to understand better, suppose a fiduciary such as a real estate agent. Now you have a fiduciary relationship there also because he is supposed to serve you and you trust him that he'll get you the best property, and you sometime entrust the funds also with him. So such a real estate agent misuses the fund they were entrusted with, leading to breach of trust. Now this can have serious legal implications if that some same agent then behaves negligently by failing to disclose known defects in a property leading to injury. The agent could face up both a breach of trust claim and tortious claim for negligence. What has happened here again? Two components. One is there is a breach of trust, breach of contract happened because I have given this agent money, I have entrusted my funds to him that you please do upkeep of my property, and you bring in tenants and you recover the rents and you pass it on to me, you cut your commission. But what he has done or she has done is they have used the money in name of maintaining my house, but they have not done. And when I came to know about this, we have filed a breach of trust claim against him under the civil law. We can also file criminal law related cases against him. But what happens if those damages which has happened to my house, which were not repaired, which were not fixed, that those have caused me some kind of injury? So he had not managed the one of the doors of my house, which was very old and creaking, and because of that, one day when I opened the door, I'm already in a situation state of fighting a legal matter with him in the criminal matters or civil matter, breach of trust. But what happens if this happens to me? The damage to my bones, damage to my door, damage to my property, it has broken my basin in the room as well. It has broken couple of more things in my home while broken. The tiles are broken. So the damage has happened. The whole wall is damaged. The whole place where it is fixed is damaged. I have to replace I would not have replaced that if I would have maintained it. So all the damages is in a fiduciary relationship with the person. You have a trust based relationship, and in that the trust is broken, but the recovery in certain cases, in spite of a loss of fiduciary relationship, the trust relationship, it is recoverable by tort. Let's take another example. A lawyer mismanages or a CA mismanages a client's fund. So the breach the fiduciary duty of the client. So either a lawyer or either a chartered accountant, they do misappropriation of the fund of the client for the purpose they were supposed to be used. They have not used it. They have not released the fund at the right time to the right people. Now, if the lawyer or the chartered accountant also causes emotional distress to the client through deceptive practice, the person might be trusting and sitting in some other country, some other city, and they have a very long trust, running trust, and they are very much upset. So this deceptive presence, they might have an emotional outburst as well, emotional distress as well. The client can pursue a tort claim for psychological harm caused because I trusted you, I trusted my money into you. I've not only lost the money, I've lost a lot of things, plus I'm completely distressed by loss of trust. So, alongside any claim for breach of trust, this is a financial misconduct also, but then the recovery of such emotional distress in terms of financial numbers, as I said, numbers cannot make you happy, but it at least something you have got in terms of return of your loss. So this was point 5 talked about crime distinguished. Point 6 talks about the breach of contract distinguished. Point number 8 talks about breach of trust distinguished. We distinguish all these three from tort. Now, tort and quasi-contract distinction. So, quasi-contracts are obligations imposed by law to prevent unjust enrichment, where no formal contract exists. This is separate from tort law, which involves wrongful act causing harm. Take an example. Imagine a painter who by mistake, paints a home thinking it was contracted. The homeowner benefiting from the work performed may be obligated to pay for the value of the service provided even without a formal agreement. But this is an example of quasi contract aimed at preventing unjust enrichment. But let's take another example. Suppose a business mistakenly overpays a supplier. The supplier knows the overpayment occurred but choose to keep excess. It does not report, does not goes back and pays it back. The business could either reclaim the money through a quasi contract claim based on unjust enrichment, while if the supplier has delivered defective goods that harmed the business, they could also face tort claims for negligence. So it overrides the tort, overrides the quasi contract as well. It is distinct.
So could you please repeat the example?
Sorry.
Could you please repeat the explanation you just gave for the tort and quasi contract?
So please note down the questions. We'll speak at the end, please. So now, is it law of tort or law of torts? That is also a question which comes. We'll respond to the answers at the end, Krishna, because this lecture has to be recorded continuously. Is it law of tort or law of torts? So the terminology reflects difference. This is a very common question which confuses people, and this sometimes become a question as well. So the terminology reflects differences in perspective. Law of tort often emphasizes the overreaching principles governing civil wrongs, while law of torts highlights the variety of wrongful act recognized within this legal area. I'll repeat once again. Law of tort means the principles governing the civil wrong. What are the principles we talked about? While the law of torts, when we say, instead of law of tort, we say law of torts. This highlight the variety of wrongful act recognized in this legal area. So one is law of tort is the principle itself of tort, while law of torts means the torts which are possible to get remedy through tort. So that is the difference. In a legal textbook, say for example, the law of torts, you would expect a broad discussion covering all the various torts, possible types of torts, their elements, there are relevant case laws, there are remedies, to understand the principle of law through the examples of possible law, torts. So that is the difference between law of tort and law of torts. So law of tort is the principle, law of torts is what are the various types of torts possible. So this talks about the nature and definition of the tort. What are the key takeaways from this point 1 to 10? Tort is a mostly a civil wrong. We can safely say it's a civil wrong because it embeds the principle that mostly related to compensation and recovery. But for any someone's negligence or omission or intentional action, it is independent from contract. It is not required to have a contract to get tortious relief. Eligibility for unliquidated damages. So unliquidated damages are subject of tort of law. You can always quantify the damages later once the damage happens rather than already being aware of what has to be challenged in the court as a damage. Distinction from criminal law, distinction from breach of contract, which includes the trust and quasi contract, and it has a broad applicability. It can have a little flavor of incident which could be criminal. It could be lying sometime in incidents which could be more civil. But in terms of looking from the perspective of the nature of relief sought, one has to decide they have to go into tort or either of the other branches of the law for seeking other kind of reliefs or satisfaction. So the terminologies are also talked at the end, which is the law of tort, which is the principle of tort, while law of torts means specific wrongful acts, example wise, and understand various case laws based on that. So, what is a tort law? It's a breach of civil law. It is based on the requirement, how you want to move forward. By the nature of it, you want to take it criminal or you want to keep it considered into in a composition based. So main types of tort what we spoke until now is negligence can cause a tort. There might be intentional tort where somebody has thrown a rock on my window and it has broken. There might be strict liability tort, which is negligence or intent, does not depend on negligence or intent, applied in case involving defective products or hazardous activities. The car example. It is different from criminal law. We understood that. Uh, we know that in case of tort, somebody could be liable in spite of no contract existing. So that is possible. Unliquidated damages are a benefit because you exactly know what you need to claim depending upon the damages. You measure the damages and corresponding to that, you get the compensation. The duty of care, what we spoke about that, is a legal obligation. So which requires individuals to act towards others with the standard of care. If that duty of care is one of the element, duty of care is one of the element, that is a reasonable, a prudent person will act according, will exercise in a similar circumstances in a very careful way. So the duty of care is something which is very, very important for anybody to take care while they act in any scenario. If someone's failure to uphold this duty of care, that results into a tort situation. So if that happens, a duty of care is not there, a tortious situation can arise. While secondary, it might be secondary also. Primarily, it might also attract criminal and civil kind of liabilities. And the significance of a reasonable person, when we talk about a reasonable person who will take the duty of care, the reasonable person considered in the subject of law is a standard, is a legal benchmark. The reasonable person you might hear in multiple other acts, reasonable person, reasonable act, prudent person, duty of care. So reasonable person is a legal benchmark. This is used to determine whether a person's action in a specific situation was negligent or not. What is a logical way of responding to a situation which is not harming anybody and which any prudent person would have done, that person is considered the hypothetical reasonable person. So it evaluates on that baseline an average person would do to assess whether the defendant's conduct was fell short of the reasonable, falling very short of the reasonability in terms of their action, or it was at the expected standards. So mostly the tort cases are resolved through settlements or trials, like again as civil matters. Either there are settlements where they negotiate among themselves and try to settle something among themselves, or they want to, which is called the agreement outside the court, or they might go for a trial, and the trial, then the jury, the judge, the panel, they decide depending upon which forum they are going. And in terms of damages, the tort looks mostly from the wrongdoing, what has happened, to reinstate you back to the situation. And yes, you can sue for emotional distress, which cannot be quantified, is also possible to be done in case of tort. So there are certain essentials of tort which we need to know. One of them is a set of words called acts or omission. Act or omission. I've been using it since the start of the lecture, that somebody acts or does an omission which has caused so and so. So to read further the subject of tort, certain definitions are called essentials of tort, are required to be known. These are the foundations. So that in future, when I come back to those parts of the tort, I can just call out those words and you know what it is. So in tort law, act refers to a voluntary physical action that can cause any harm, whereas omission is the failure to act when there is a duty to do so. So they are opposite to each other, and both can lead to tortious liability. So act refers to a certain act. Why we are talking about action that cause harm? Because in terms of laws, when we study, we are not bothered about the acts which are causing no damage to us. We are bothered about the word acts definition, where a voluntary physical action which has caused harm. While the omission also similarly is failure to act. It's like light is presence of photons, and darkness is absence of light. Very same way, act is voluntary physical action which can cause harm, while the omission is absence of this act. So omission itself is not an act. Omission is absence of act. So a driver runs a red light and collides with another vehicle. It causes injury. The driver's action constitutes a tort because it resulted into an act which caused a harm. He did an act of violating the traffic principles, the rules. This act caused an accident. This resulted into a tortious situation. While, say, a hotel owner, a restaurant owner, who is not cleaning his floor, there is oil spilled, food spilled on the floor. Somebody comes and falls down. This is an omission, absence of act of cleaning the floor. That is where the omission has caused a tortious situation. Then the next word, if you see in the list below, I'm coming to point number 2, the legal damage. So legal damage refers to harm or injury that is recognized by law, which allows a party to seek compensation. Damages must be established to succeed in a tort claim. For example, an individual is hit by a falling object due to negligence on a construction site. The resulting injuries and medical expense demonstrate legal damage permitting the victim to claim compensation. A person suffers from defamation. We talked about the famous person who was defamed by a false statement on the newspaper which was published. The emotional distress and loss of reputation constitute again a legal damage that can be remedied. So legal damages could be physical and emotional, mental, etc. also. So the legal damages, which is nothing but a harm or injury which is recognized by law. It could be physical, it could be psychological, mental, whatever it is. The third uh, essentials of tort which you need to remember is injuria sine damno. So this is a Latin term meaning injury without damage. So a situation where a legal right has been violated, a damage has happened to you, some loss has happened to you, but actual damage has not occurred. So you can sue for the violation of this right as well. Even there is a no physical harm. For example, if somebody trespasses on another person's property, now its cause constitutes an injury to the property owner's right because you are not allowed to be trespassing in my property and you have injured my rights. Was there a physical damage? No. Did you made a physical damage to my property? No. Did you made a hole, blast, anything there? No. So there is no physical damage, but I can still file a lawsuit against you for trespass, asking for certain nominal charges against the nominal damages by violating my rights. So injury without damage is also be possible in the tort to be claimed. For example, a person is falsely accused of a crime. For example, a false case of sexual harassment. Somebody does it by intention. So there is a huge reputation harm of that person. Although no financial loss, his job is not gone. Probably over time, people understood it is not right. But that point of time, he has gone through a lot. And his claim for defamation could be also claimed under this tort. Point number 4 is damnum sine injuria, damage without injury. So first one was injury without damage. You can claim for injury of your rights when there is no physical damage. The second one means damage without injury. Injury without damage, damage without injury. The concept occurs when a plaintiff suffers a loss but is not entitled to relief because no legal right has been violated. Take an example. A company loses business due to legitimate competition. Although it suffers financial loss, no legal wrongdoing has occurred. So the company cannot sue for tort. Whom they will sue? Who has created this? So in that case, all the situations where the situation is like a damage without injury, there cannot be a claim. So injury is a very important ingredient for the claim under the tort, and that is why injury without damage is also applicable. But any damage which has happened without injury, nobody could be made liable to pay for that tort. For example, there is a land lying next to your property, and a legitimate user buys and makes a legitimate building, which is stopping the scenic view used to enjoy earlier. There was a huge hillside view next to your plot, which is now covered. But it's not a legal wrong because the person has rightfully bought the land. He has done the structure rightfully. So there is a damage which has happened to you for yourself, but there is no injury. So no tort has happened. So this is about point number 4. Let's talk about point number 5, mental element in tortious liability. Now, the mental element pertains to the state of mind of the defendant when committing a tort. So, in many tort cases, the concept of fault of intention is very relevant, like in anything in the other laws as well. So, for example, an intentional tort such as assault, the offender must have intended to cause harm or fear. So, if somebody is doing an assault, definitely the person has intentions to cause harm or fear at least. The presence of intention is also a kind of element which is very, very important. And the intention influence the liability and potential damages could be awarded in terms of tort. While if in negligence case, The defendant is judged based on standard of care. We talked about just and care person. So, if they acted carelessly, the mental element reflected lack of intention, not wanting to cause harm, but still results in a liability. Let's talk about point number six, fault when relevant. This is also a very important term in terms of tort. So fault is a crucial concept in tort. I said the injury is also a fault. So cause of fault. So fault is a crucial concept in tort law, and it encompass negligence or intention. So it might be intentionally done by act or by omission, which is negligence. So act and omission convert into intention to do something or done after that or negligence. So the presence of fault is often necessary to establish liability. So if somebody is at fault and the injury has happened, the claim in terms of intention or negligence can be made. This is mostly the case of medical legal. So a doctor fails to diagnose a treatable condition and he is not able to put a reasonable care to the patient who has surrendered to him for treatment in the hospital, patient can claim a damage. Or a surgery which the doctor has done and he leaves a towel inside the stomach of the patient. It is again a fault. So this is something which is negligence based loss which could be claimed. While in case of intentional tort, say for example, there is an heated argument and a couple of people fight and one person receives injury, he needs medical treatment. So this is an intentional act based fault in the situation of battery and the tort is invoked. So this is fault when relevant. So these are fault when relevant, which are causing loss. These are causing fault is causing injury. This fault is because of either negligence or an intentional act. Liability without fault. So we talked about fault and the liability arising out of it. Let's talk point number 7, liability without fault. So some torts impose liability regardless of fault. These are called as strict liability. This is a strict liability, we say. Because it is regardless of any fault, this tort has happened. This is no fault liability. So there is no fault, but there is a liability. What is it called? It's called strict liability. So the defendant can be held for the damages in such cases as well. And only thing what is required is they have to pay. Proof of negligence or intent is not required. Let's take an example. Say a company that manufactures a, a defective product, our car example, may be held for injuries caused by the product, even if the company took all reasonable precaution in the manufacturing process. So when that point of time, my car has hit the wall and the people, I have sued the company for the uh, damaged equipment they have produced. They might have already a quality control in place. In spite of that, in a high probability of having, say, 1 in a million, the device was created which was faulty and it caused damage to me, which was a liability without the fault of the company. Company never intended to make a low quality product. They had a very good quality check, but 1 in a million was the possibility which was approved and agreed also as per the quality standards. Nobody can have a control on that. So without a fault, still there is a liability on the company to pay. The case involving wild animals also. An owner may be liable for injuries caused by their pet if it attacks somebody, regardless of owner's fault. If it is closed in a vicinity, it is chained, still for some reason the chain breaks, the wild animal or the dog comes out and it tries to bite it bites somebody. Was it the fault of the person? No, it wasn't fault of the person, but still the liability is there. So still the tortious liability is on the owner of that animal. Point 8 is the trend. So the trend in tort law has shifted towards increasing accountability, which with a focus on protecting victims' right and providing remedies for harm. There has also been an expansion in the types of claim recognized under tort law. So the law of torts have increased now. There are some special kind of torts which has come in the cyber world, which is like privacy invasion, giving uh, psychologically distress to person by invading their personal life through digital media, or cyberbullying, or chasing somebody cyber following, and due to multiple product liabilities which are not working, if not working the way they were supposed to work. So all those things are new kinds of torts which have come up in the law of torts. What is law of torts? The kinds of tort which can happen. So the rise in personal injury claim related to a lot of toxic torts also. Claim arising from harmful substances. Because nowadays pollution is something which is a very important attribute. Somebody burns some garbage. This is again one of the tort, because you are not allowed to make public nuisance by burning something which is increasing temperature and pollution. There are victims of emotional hazards as well. For example, uh, somebody done a victim of a cyberbullying. Then there are victims of environmental hazard also, which were not earlier part of the tort. For example, recently some companies were supplying contaminated water to people in Pimpri Chinchwad. So these are all where a compensation can happen, and that these are new kinds of torts. So cyber torts, environmental torts, and chemical exposure torts are a large number nowadays, and these are both tortious liabilities of both physical damage and emotional damage kind. Point number 9 we talk about is malice in law and malice in fact. So malice also, what we talk here about is the legal malice. Refers to an intention to commit a wrongful act, bad intention, without justification. While malice in fact pertains to the actual intent behind a person's actions. So malice in law is an intention to commit a wrongful act. So there is an intention where I am aware I am committing a wrongful act, and but I want to do it. And I have sometimes I am doing an act where I have no jurisdiction also. That also becomes a legal malice in law. While malice in fact means the actual intent behind a person's action. So for causing that malice in law, where I've committed a wrongful act, or I've committed something which is without justification, uh, still that, but I was speaking CRPC before that. So jurisdiction came instead of justification. So justification, right? So this is something without any justification, you will do some wrongful act. That is malice in law. But malice in fact means the pertains to the actual intent behind that malice in law. Why I have done that action. So malice in law might be applicable in a defamation case, where an individual knowingly spreads false information about me and other persons. The speaker's intent to harm reputation may constitute legal malice, leading to potential damage. So the legal malice in this case have got me potential damages. But in case of an assault, if a person attacks another, not only with intent, but a desire to inflict severe harm. So I have a desire not to do a legal malice. I want to harm you as well. They are displaying malice in fact. This intention can increase liability for damages awarded in tort proceedings. So the malice in fact has higher price coming in terms of liability as compared to malice in law. Now let's compare malice in fact to evil motive. What is the difference? So malice in fact we say is an evil motive, is also called as evil motive. So indicates an individual's intent to harm or inflict injury upon other, which often inflates the degree of culpability in tort cases. It takes it more towards crime. Now it's weighing toward more towards the criminal side of it. So malice in fact, which we discussed in the previous point, is also referred as evil motive. That is the evil design of my thought, where this, because of this malice in fact, I not only wanted to harm and you, but I wanted to completely injure you. So the intention is not, with the person attacks not only with intent but also with a desire to inflict. So intention is not only there. I'm trying to inflict a injury as well. So if an individual maliciously spreads falsehood about a rival to sabotage their business, this demonstrates an evil motive. If sued for defamation, the malice could lead to punitive damages in compensation, while in case involving intentional infliction of emotional distress, a person deliberately engages in harassing behavior towards another with the intent to invoke fear or anxiety. The conduct exemplifies malice in fact. So these are malice in fact. While malice in law is something where, uh, for example, a defamation is happening, it is damaging the reputation, but it is not having any physical damage on me or any emotional distress uh, through malice. Malice of fact is not generated here. There are exceptions to these rules as well. So in the tort, there are certain exceptions where traditional principles may not apply. Recognizing these exceptions is important for understanding when liability might exist even in seemingly clear suspicion situations. And say, for example, um, in the doctrine of sovereign immunity, which protects government entities from being sued unless they waive this immunity. So there is a sovereign immunity given to protect government entities, certain entities. Now, this can complicate tort claims because against the public officials for actions taken within the scope of their duties. So, if an army man who was in a duty in Mumbai to fight the terrorist attack, and in that sovereign immunity given to him under CRPC also, which is recognized, if during this uh, some injury happens to some property by mistake or some persons by mistake, this is very difficult because this is done in scope of their duties. Another exception, for example, contributory negligence, where the plaintiff owns negligence contributes to their injury. So their plaintiff's own negligence has caused their injury. For example, uh, somebody was using some machine and it was no fault of the machine, and the machine has not been used properly with the right precautions and an injury happens, then the company cannot claim, the person cannot claim to the company because this injury has caused because of his own contributions to get that. So couple of exceptions are there. Two we have spoken right now. One is the sovereign immunity and the contributory negligence. The point number 12 is tort remedy by way of writ jurisdiction. So in many legal systems, tort actions can be pursued through the courts via writ jurisdictions, whereby a plaintiff can seek remedies through formal legal process traditionally recognized by common law. So when we talk about the trial or the out of court settlement, the out of court settlement is either done first, or it is a product of first you file a writ petition and then parties try to agree and compensate each other by way of out of court settlement. But if it does not stands happily with as per wishes of the plaintiff, in that case the matter will go for trial. But the trial what you have instituted in the court court of law, that is nothing but a writ petition you have filed. So a claimant may file a writ summons in tort case to initiate legal proceedings against a party accused of committing a tort, enabling them to seek damages or relief as prescribed by the law. So either they go back and seek damages, and the last statement what we say in the prayers, whatever the judges feel better in terms of providing the right justice, they can come and bring some additional relief or downsize the expectations of the plaintiff. In some cases, a plaintiff may pursue a writ of mandamus, etc., to compel a public authority to perform a duty. For example, that could also happen for uh, a court to court, asking a higher court to ask a junior court to comply with certain actions which they are supposed to do which they have not done. So perform a duty owed to them arising from tortious conduct, such as seeking a safety measure that has not been implemented by a responsible department or whatever it is. So in case of writ of mandamus could also be filed. So essentials basically of the tort, they are the foundation of understanding on how the liability is determined, what are the elements which will be used across when we talk about tort, and these are the things which will be part of the studies of tort, what we will do. So act and omission we have read. This is very important. The tortious situation can happen because of tort, act or an omission. But in act of a negligence or contributory kind of omission, which is done by inflicting pain or injury to ourself, is not maintainable. It's one of the exception. Legal damage, which is very well recognized in the tort, and this is a harm or injury which is recognized by the law, while injuria sine damno, which is injury without damage, is recognized in tort, the other way around, damnus sine injuria, damage without injury, is not recognized. And the materials which are important is not only quantifiable in physical forms. These could be also quantifiable by mental abuse and harassment as well. And the fault, what we talked in the law, wherever it is relevant, is if a fault happens and which is causing a particular injury, whether the intention was there or not, there is a subject of fault when relevancy, where we say fault in a law typically refers to the responsibility of the party, and it is particularly relevant if negligence claims where the plaintiff must prove the defendant failed to meet the standard of the care. So the standard of care, if it is not done, a fault happens, then it is a tortious situation. Liability without fault we studied in point number 7, which referred to as a strict liability. Means a party can be held responsible for harm caused by the action regardless of intention of negligence. We talked about the manufacturer's fault, defective machines, machine parts being created. Current trend, we talked about, there are some trends around which could be about the various kind of new kinds of tort like cyber related, environment related, chemical pollution related. Distinction between malice in law and malice in fact we studied, where malice in law is referring to an intent to commit a wrongful action without justification, without any reason, justification. I intend to commit a wrongful action. While malice in fact pertains to an actual evil motive or intent behind a person's action. And the malice in fact impacts the tort cases, and because how it impacts that the court may award a higher damage, including punitive damages, when malice is established, because it is a harmful intention to goes beyond mere negligence. It is something which is planned and done. Exceptions are there. For example, sovereign immunity or contributory negligence, which is given respectively either to some government officials in certain specific areas in their line of duty, or contributory negligence where you yourself has damaged yourself. And pursue a remedy through is always done through jurisdiction or even mandamus. Um, Court determines negligence in tort cases, which is very common, and they use a reasonable person standard to justify. The scale is reasonable person, which is an hypothetical person who would be a reasonably prudent person who will act in certain way, which is something done with a duty of care, and a breach of duty, if happens in that condition as compared to the standard person, then it is considered a breach by the courts. Causation which is linking to the breach of the plaintiff's injury, that is also considered, and the plaintiff's actual damages, which is unliquidated damages, is something which is considered by the courts in giving the judgments. And the damages which can be awarded in the tort case, the three types of judgment which we say is compensatory damages, punitive damages and nominal damages. So compensatory damages are something which is restore the plaintiff to the position they were in before a harm. So we are compensating and covering medical expenses, lost wages, etc., and property damages. The punitive damages awarded to punish the defendant. Punitive is related to punishment. So punishment is also particularly to deter similar conduct in future. So this is mostly for the malice in fact or gross negligence areas. In fact, in the new laws in BNSS, there are possibilities of social services also in terms of punitive damages. Nominal damages is awarded when a legal right has been violated but with no substantial loss. For example, trespassing. So grievance is there, a right is damaged, no future, the physical, no mental damage has happened. In case of those, nominal damages are awarded. And there is a very good space of emotional distress which is recognized in the tort and which is called as intentional infliction of emotional distress, IIED. So intentional infliction of emotional distress is regarded, or negligence infliction of emotional distress, for example, in medical case, is also recognized. So this all brings us to the end of the lecture today. Now we are stopping the recording. We'll take the questions after that. Give me a moment.